You're listening to the Valley Current.
So what were the facts in the case, generically speaking, that you have or that you've heard recently?
Right. So one of my tax clients for many years, a widow, elderly and hard of hearing, somehow got convinced to do a large Roth conversion.
How old are a widow, roughly? Over 70?
I'm not good with women's ages.
Okay. But you think probably over retirement age, if I say retirement age is 65, right?
Absolutely.
Okay. Based on the tables, maybe her lifespan is another 20 odd years, maybe, depending on COVID.
I can't predict the future either. I can tell you that there's two classes of people who complain about taxes. There's the men and the women.
So she has a wealth advisor, which means she must be pretty well off because most people don't, right?
Yes. Well, even, people of moderate assets have, here in California, at least, have real estate. Mm-hmm. And with the average house being worth, $1 million perhaps, we're talking significant dollar amounts, even right. For an average person who's been working or has a spouse who's been working.
Right.
My client's spouse passed away a few years ago.
Okay.
And, in any case, the financial advisor encouraged her to do this, make this large conversion. And her tax advisor, I was not consulted.
Okay, so basically the financial advisor, who's the wealth advisor, looked at some data, not the tax situation, but just some data and said, hey, maybe it's an opportune time to convert your traditional IRA into a Roth IRA. Now, my first question would be, was there effectively some thinking along the lines that there was going to be an inheritance of the IRA and some concern about whether the inheritance would somehow be better off being a tax-free inheritance down the road? Like sometimes I hear wealth advisors, financial advisors, the same people say, well, if your stocks take a beating, maybe now's the time to do the conversion because the stocks are way down. And when they travel back up, let them travel back up in a Roth IRA. I've heard that argument made in the past, like in the 2008 timeframe when the market got hit pretty hard by the recession of 2008. There was a view that, well, maybe now is the opportune time to convert a traditional IRA into a Roth IRA on the view that, well, these stocks will eventually come back up and then all that gain will be withdrawable and there'll be no required minimum distribution. So you can just let it keep accumulating going forward if you have a plan of longevity.
That's a complex question. And having not been involved in the decision, I can't really say what crossed their head or what motivated them.
Right.
But any Roth conversion would potentially be taxable now, depending upon their holistic tax situation. What income do they have this year from all sources?
Right.
So if their income from all sources is in fact negative, then potentially some of the retirement assets might be converted to a Roth tax-free. But exactly how much of those assets could beneficially be converted requires a tax analysis.
Right. So the wealth/financial advisor is not really a tax expert and isn't really looking at, well, let's look at your 2022 tax information and let's run it through some spreadsheets. And I imagine the punchline of the story you're going to tell us, but I don't know it for sure, is she probably was surprised at how much in taxes she has to pay with current assets, right? In light of your running the calculations of what the real cost was of doing this Roth conversion, right?
Exactly. So her decision to do the Roth conversion ends up costing her tens of thousands of dollars that she was certainly not expecting, and that would not have had to be paid had she not been encouraged.
So that's sort of the gotcha here, because I don't think these conversions are reversible, are they?
They were reversible before the 2018 Trump tax changes, the Tax Cuts and Jobs Act of 2018, which did a bunch of, which had a bunch of strongly negative effects upon certain particular people in difficult circumstances, such as an elderly person who has mistakenly entered into a Roth conversion, or somebody who's had large theft losses. And I think we've seen other cases of that nature as well. But some of these people in hardship situations, fixed income, et cetera, potentially were adversely affected by these 2018 tax changes. And one of them is that we can no longer reconsider Roth conversion.
So that to me suggests that the wealth manager, financial advisor guy or gal really should have probably thought really long and hard about getting your advice, maybe even getting some estate planning advice, maybe getting some legal advice, because it's not like, well, if we make a mistake on this, you can always flip the switch and get a refund or do something else. Once you make this decision, it's pretty much in cement, right?
Not only the financial advisors out there listening to this, but also the brokerage firm that was custodian of these assets needs to look hard at their process for ensuring that a vulnerable elderly person is properly advised and properly authorized in their trade or conversion. Mm-hmm. Because the brokerage firm is deeply involved in this situation as well.
So she must have been, without naming any names, she must have been pretty horrified to hear the numbers, right? Like she hadn't really heard them before, right?
Indeed. And she initially and still probably blames herself.
Oh, she blames herself for not thinking, hey, maybe I really need to call up my tax person, my tax expert, Steve Rabin, and see what he thinks about this?
Indeed, yeah.
And so I guess you get to this question of, well, is there a fiduciary or fiduciary-like duty on the part of the wealth advisor to say, look, I'm not a tax expert, and I think this is the right thing to do in general from everything I'm hearing from you, but I don't really know whether the tax consequences are going to be so adverse that you're going to be upset about doing it. So let's get other people in the loop to make this decision together. And that just didn't happen here, right?
I've seen this often, in fact. So it's not just this case, but throughout my career, I've seen at least twice the rate of people who face bad tax consequences for using a Roth retirement vehicle inappropriately versus a very small number of people who've used a Roth retirement vehicle well. So, for example, I was recently on a conference call with a group from Financial Executives International, and these are all CPAs and corporate accountants. And one of them was talking about her personal tax decision and how she was confused about the use of Roth retirement plans. And she decided she'd balance her situation by allocating 50% of her retirement contributions to the Roth and 50% to the traditional. so that way, if she went wrong, she'd only go wrong half as much. And I told her, well, there's a problem with that, because what you're doing is like shooting yourself in one foot instead of shooting yourself in both feet.
Right.
And you should leave the Roth entirely alone. You are a highly compensated W-2 employee and you pay large amount of taxes, and you want to defer. You do not want to accelerate the taxes, even half the taxes. You do not want to accelerate them. You want to defer all the taxes and not use the Roth.
Right. So when you look at what her choices are now from a tax point of view, does she have any real choices at all? I mean, at this point, is there any real choice that she has in how she handles this?
Now, that's a great question. But I think it's a legal question for you or somebody like you as to whether her decision to do the Roth conversion was competently authorized by her. And if not, then there's a securities law question as to whether the broker has any means of reversing the transaction. And those two questions are outside my area of expertise.
Yeah, and I think it's the kind of thing that you have to wonder what was motivating. I mean, my first question, frankly, would be what was motivating the entire discussion? Did she come to him or her and say, I really want to have a Roth IRA. I really would like to do a conversion. I've read some stuff that says it's a good thing to do in some investment magazine. Now that the stock market is down. Or was it something that was pitched more by the individual, where the individual was essentially driving it, maybe because there was some thought that he can move some of the investments into some other products of some sort? I mean, like, what's the motivation for this? Obviously, there's a whole question of what's the fine print in the agreements that she signed. But keep in mind, a lot of those agreements are still subject to elder abuse law. And if she is over a certain age, then in California, the elder abuse laws would look at what was the motivation for what was being done. And did he or she take advantage of the fact that she was hard of hearing, or she really didn't understand what this was all about? She didn't understand the tax consequences, in which case there probably is a cause of action for either negligence, which would just be the standard of care would have been to bring in some expert of some type from a tax point of view, and probably from an estate tax point of view as well, probably from an estate planning point of view too, to look at the question of what are we doing here and why are we doing it at this point in time, given that she doesn't work, right? I'm hearing she's retired at this point, has been retired for a while.
That's correct.
So my guess is maybe the required minimum distributions had to start to be made, and maybe she was somewhat against that. I don't know. I mean, that's another thing. Don't those have to be made starting at the age of 71 and a half in a traditional IRA?
Yes.
So maybe she's heading towards that age. I mean,
even though there's been an extension of that age with COVID, I believe it's up to 73.
Oh, is that right? They pushed the date back to 73 now?
It's slightly, the exact question is slightly complicated. It depends upon when your R&Ds had to start, but yes.
Okay. Yeah, I mean, to me, if you think about this, it's like a can of worms that you have to sort of open and kind of go through worm by worm to figure out what's going on. Now, I imagine that they're going to be sensitive, because typically with an older client, and particularly if it's been a long-term client, they don't want to lose the client. And so the client is, if the client is unhappy, hey, you didn't tell me that I was going to face tens of thousands of dollars of taxes, I would not have done this if I knew that. Or I would not have done this without really going through all the pros and cons and really trying to understand what was I buying for the taxes that I'm paying, the additional taxes that I'm paying now. So can a case be filed? Potentially. Does it depend on all the facts and circumstances? Of course. Does it depend on what the legal agreements say? That's a lot of fine print that these days gets signed electronically very quickly, oftentimes without even reading the paperwork, because you really can't negotiate it. I mean, you'd have to be a billionaire to negotiate deals like this. And even then, I'm not even sure these companies change their legal paperwork. They may change the rates at which they charge commissions and that sort of thing. So the paperwork is typically locked in concrete, which means it needs to be interpreted against the draftsperson. So if there's any ambiguity in that paperwork, it's going to count against the wealth advisor. And I would think there would also be this whole question of the compliance department saying, hey, we have lawyers inside our firm. Why didn't you bring a lawyer in to sort of explain to her that, hey, or an accountant in, or a CPA in, or a real tax expert in to explain. But your point is they're not as familiar as you are with all of her historical data. And you really have to know all of her historical data to understand her exact tax situation, right?
Well, yeah, maybe. And they're not as familiar with the pros and cons of a Roth. If you look at what you pulled up on the internet about pros and cons, it does not explain what I just went over. It gives you a lot of pros, and it does not say that a Roth is for almost no one. Use extreme caution. Consult your tax person. That's not anywhere here on this thing. So, can we now do a class action against Microsoft?
Yeah, I mean, to me, it's a little bit like, at what level do you have to be very paternalistic if you're in the wealth management business and you're depleting wealth? Because to some degree, your bigger point here is they've actually depleted some of her wealth. And they would say, well, we depleted some of her wealth to taxes because the long-term benefits are greater, and you're challenging whether the long-term benefits are really greater. I hear you indirectly challenging, hey, if you deplete $50,000 in taxes out of her monies now, that has a real ramification for her that the long-term benefits of the Roth IRA may not make up for. It may take many decades to make up for that. And she may not be around many decades, right? I mean,
it's more than that. It's more than that, because if she pays all the taxes now this year, then next year she could have a very bad year when her tax bracket is 0 or below 0, and when a Roth conversion would have been advisable. And she could have then done the conversion next year and paid 0 taxes. And then the year after, she could have had a very bad year, and it could have been a great year to do a Roth conversion.
Mm-hmm.
And then the year after that could have been a great year to do a Roth conversion. But once she's done the Roth conversion this year and paid the taxes, she's not going to get those taxes back. It's gone. So I think that it's a very clear situation from a tax planning perspective that doing the Roth conversion or using a Roth early in your life is almost never beneficial.
Mm-hmm.
Because there's this huge opportunity cost of all the future years when a Roth conversion might have been useful. And having done the Roth conversion in a bad year, you now the tax money is gone. You've just lost half your retirement money, and you're not going to get it back.
Right. So in general, I think there's 3 principles that come out of this. Principle number 1 is wealth managers, financial advisors, they're not typically CPAs, tax experts. They should stay in their own swim lane. they really should bring in the tax expert that they have either on staff, or even more ideally, you as the traditional tax expert, just as a matter of making sure the client fully understands the tax consequence of what's being done. That's point one. Point two, when you deal with an elderly client, I think you do have to wear some additional kid gloves to make sure that they fully understand all the ramifications, because they may not. They may see it as, they may be blinded. They may not even be able to hear it. You may well have to give them a written explanation and get them to sign. I know people that videotape some of these conversations they have with older clients to say, look, watch the videotape again before you make a decision. Sit down with your loved ones, maybe the ultimate beneficiaries of your estate, and get their advice and their pros and cons on this before you decide. But make a deliberate, conscious decision. That's point two. And then point three is, oftentimes, even the smartest people in the world make mistakes in their financial planning. Elon Musk is probably one of the smartest people on earth. He used to be the richest person on earth. I think he's made a huge number of financial mistakes in the recent period of time. I think he's almost acknowledged that to some degree. So even when you are the smartest and richest person on earth, you may just react in the moment and not think twice about, well, do I type out this tweet that says I've secured funding at 420 because that could really move the market and that could affect things? Do I buy Twitter? Do I make an offer? I mean, even with all the advisors that are around him, I mean, we're all flawed as decision makers. And so you would think that someone in the role of being the financial advisor would really want to make sure that there's as much expertise brought into the picture. I mean, it wouldn't have been that costly. I imagine you could have picked up the phone during the meeting that they had, assuming they had a meeting. Maybe they just did it by Zoom. They could have brought you into the Zoom and said, what do you think, Steve? And you would have probably said everything you said during this conversation.
I would have, Jack. And I think if I was at the broker in the controls and compliance department, I would put another piece of paper into that authorization process where the tax advisor has to sign to say that they've been consulted. And that would almost guarantee that the proper tax advice was obtained.
Mm-hmm.
So, but, when somebody is as successful and wealthy as, Musk or some of the people we're thinking about, pride goes before a fall.
Yeah, I mean, to me, it's sort of a question of, did they even know you existed? Because you would think they would know just by asking, who does your taxes?
Exactly.
He or she should probably weigh in on this decision, because there's going to be likely some tax hit. They knew what her income from her investments were.
Yeah, just have a piece of paper with 3 checkboxes. Checkbox 1, I prepare my taxes myself. I have no tax advisor. Checkbox 2, consulted my tax advisor and they approve. Checkbox 3, I've consulted my tax provider and they disapprove.
So let me ask you a weird tax question that flows from all this. Let's say she brought a lawsuit. I mean, look, she could bring a small claims case for up to $10,000 herself. Now, that's probably only a fraction of what she's lost, but let's just hypothetically leave the legal fees out and pretend that she goes to small claims court and she has enough capability, she's able to hear and so on, sufficiently to convince the judge that what happened here was really negligence on the part of the wealth planner or the wealth advisor. And she wins $10,000. Is that $10,000 income to her? or is that $10,000 like return of property? Like what happens to that $10,000? Assume no legal fees, assume assume she files the case and they just pay her the 10,000, because the jurisdictional limit would essentially act as a cap on their liability, and the rule that there's only one form of action that can be brought. She can't bring multiple small claims cases to try to get all the losses. She'd be waiving any of her damage rights above 10,000 if she chose the small claims court method or approach. We'll talk in a minute about the other approaches. But my question is, if she got that $10,000, how would it be characterized from a tax point of view in, say, 2023 when she got it?
Now, that's a great question, and I do not have a 100% answer in my head. Okay. So I have to get back to you on that.
To me, I think the presumption would be it's some form of damages and not for a personal injury. So it's just damages for what was negligence that caused the financial loss. So your point is, but she had kind of an economic loss that was larger, but that economic loss is not deductible. That economic loss was, you made a choice, it might have been foolish, but cross your fingers and hope that the long-term benefits of the choice outweigh what the front-end costs were, right? I mean, that's where my head goes, is in giving her the full picture of, well, what's going to happen if you go forward with this case? Well, if you win all the money with no legal fees, you pocket the 10,000. But if we have to report it as taxable income, you're going to pay taxes on that money, which is
it's a good question, and I do not have an immediate answer. I'll tell you, if you run a business and you break the law and you get penalized for breaking that law, that penalty is not deductible.
Right.
You might think it's a business expense, but no, there's a specific code section.
Right. So it may fall into kind of that sort of category in a way. But now let's take case number 2, which is the paperwork has what I would imagine it has, because I've seen this over and over again, some type of binding arbitration clause, and her elder abuse arguments are not sufficient to knock down the arbitration. She goes to arbitration. Now, she could do the arbitration herself, but the arbitration is typically complicated enough that she'd have to bring in an attorney. And whether the attorney could recover legal fees will depend on what exactly gets arbitrated and what exactly is in that agreement that she likely electronically signed. But typically a contingent fee lawyer would charge 33% of whatever she recovers. So let's say she had a loss of, just to use round numbers, $30,000. And the contingent fee lawyer tries the case in arbitration, wins it, and gets paid $10,000 as the 1/3 of the $30,000. So she gets back 20. She's still not been made whole because she lost 30, but she had to pay a lawyer, right? Unless there's a fee shifting statute. She has to pay her lawyer a contingent fee. She gets 20. If that 20 is not deductible, then, or that 20 if that 20 is considered income, she's going to pay taxes on that 20. Presumably the 10 that was paid to the lawyer would be considered deductible. So if she reports the 30, she would take 10 out, representing the lawyer's fees, but maybe that's a problem too.
That is a problem too. And in some cases, you can bring a lawsuit and actually win the lawsuit and end up paying more than if you just walked away from the whole situation.
Right. So you have to factor that into the analysis. And then round 3 is, let's say there is no arbitration. The attorney's advice is file a lawsuit, bring the elder abuse claims, try to get the maximum personal injury damages, which may be not reportable as income because personal injuries are treated differently, and punitive damages. Try to get punitive damages that would boost the numbers even higher. So that attorney would be looking to maybe get a 7-figure outcome, some very large multiple, although generally there are constitutional limits on attorney's fees. They typically can't be more than 10 times the actual amount of the compensatory damages. That's a whole different subject for a whole different podcast. But just conceptually, if that bell is rung, then the attorney would get 1/3 of a much larger number. She would get 2/3. And then the question would be, is that money much more for some sort of personal injury that is not taxable, as because she's been caused emotional distress and that sort of thing, and she has physical complications to the emotional distress. This whole area gets very fuzzy as to where the lines are between income that's compensably, that's reported as compensation and taxable versus return of some sort of lost arm or lost leg. You know, you lost some property, effectively, you're getting compensated for it, but you really didn't, you shouldn't have to report that as taxable income. But conceptually, she's got to do almost that level of analysis, because she's going to put in a lot of her own time. And as you get older, time gets a lot more valuable than money. As we all know, the utility of money decreases in time. I don't know anyone that on their deathbed says, you know, I really want to stay alive another day so I could, you know, spend more of my money. Well, maybe someone said Jack Welch said that on his deathbed. You know, the guy who was a long time CEO of General Electric said, man, I just wish I could have spent more of my money. But people will trade money for time every day of the week as they get older, because the utility of money is going down, down, down over time. You just can't spend it as you get older, particularly if you start losing mobility. So it's an interesting question, like, how does she treat the 2 years that a substantial litigation may take through whatever trial and appeal process that occurs? That has to all be weighed by her as well, which is significant.
You know, Jack, from my perspective as a CPA who has taught other CPAs many subjects, including ethics, there's also the question of how many other people are going to be encouraged by this broker to make the same mistake. And do I, if I were her, would I have a moral responsibility to all these future people who might be misled by this broker? Should I do something to fix the system to help make sure that future investors don't get harmed this way?
Yeah, I mean, it's a big question, because I think there is a compliance issue checklist that these wealth management firms have, and I've got to believe there's an internal checkbox that didn't occur here, because they don't want to see unhappy customers. This stuff shouldn't really have happened. Maybe it was an overambitious wealth manager. You know, maybe it was someone that wasn't really thinking carefully about what the hell they were doing here. I mean, I don't know what the answer is on that, Steve. I mean, it's an interesting question.
In agreement.
So, you know, to me, it's sort of like she suffered a loss that's irreversible. The statute of limitations would allow her to bring a negligent misrepresentation claim, which is not fraud, just negligence, within 2 years of the date she suffered the loss. It sounds like you would say the loss is going to be suffered as of April when the taxes are paid, and there's no reversibility on that, right?
Right.
So, you know.
Though a case could be made that the losses were suffered when she consented to or executed the Roth conversion, which would have been 8 months sooner.
Right, but she didn't really know. I mean, and the actual decision itself, whenever that paperwork was executed, I don't know, how quickly did they give her a lot of time to think about the issue? Did they say to her, here's the paperwork, you can decide, take your time to decide? Or was it like, you got to do this, you got to do this now that, the end of the year is coming, that sort of thing?
I was not there. There's one other time point that's possible, of possible relevance, and that's when she received the 1099 that notified her of the investment income resulting from this.
Right.
And that's happening about now.
Right.
January or February.
So to me, she's got to calendar some dates. I like to say, don't wait more than a year just to be protected. 2 years on the outside. Technically, breach of contract is 4 years, but I don't know, breach of contract is not really a tort. You want a tort claim that would justify punitive damages. That's either going to be breach of fiduciary duty, which is 3 years, or negligent misrepresentation, which is 2 years, or both, which means you go with the shortest date, which would be 2 years. So in general, she has some time, but I would say the problem, if it's not going to be a 6-figure or maybe even ideally a 7-figure case, most contingency lawyers don't get too excited about cases like this. And what a lawyer could do for her is to say, look, let me see if I could push this case into mediation or negotiation, because you have some leverage, which is you're an unhappy client. And you have a spreadsheet now from your tax expert showing some numbers in terms of the data. And he's your expert witness on what happened here is upsetting, and it shouldn't have happened. And she would have been better off. Now, maybe they can make a case that they explained all that to her and they documented it. You don't know. You'd want to know. Did they document it and say, look, there are downsides. You're going to pay some maybe significant taxes. And did she understand that? And she have enough time to think about it? And maybe they even said, you should discuss this with your tax advisor. And maybe even that paperwork said that. So you got to go through kind of all those details. And ultimately, that would all be subject maybe to a negotiation or a mediation that would avoid some of the time costs and some of the legal costs. I mean, that's what I say about these small cases. They want to keep the client, and they don't want to lose a customer. They don't want social media to expose their mistakes, right? Because that has an impact. They want a happy customer. And if they made a mistake, they should, from a fiduciary duty point of view, own up to it. And they should say, look, we made a mistake. We really should have gotten your tax accountant involved. And it's unfortunate that we didn't do that. So, Steve, we've spent a fair amount of time on this, but I think it's useful for folks to know that these decisions are not to be made lightly. And this Roth conversion area is tricky and requires really looking at all the pros and cons, and not just punching some questions into Chat GPT and seeing what gets spit out from that system. Although your point that we started with is accurate, which is maybe if they gave some links to the sources, and the sources were the IRS reports and that sort of thing, maybe one could delve in more deeply, and you're getting kind of the beginning of a research brainstorming effort, which is okay to get started that way, but you have to go further than just going with whatever answer Chat GPT spits out, right?
There you go.
Okay, Steve, thanks. You have a good afternoon. Good seeing you today.
Likewise, Jack.
Take care. Tell folks how they can reach you.
So my cell phone number is 408-887-6433. And my email is srabin@srabin.com. That's S for Steve, R-A-B as in Bravo, I-N.
Thanks, Steve. Take care. Have a good day. Bye-bye.
Likewise, you too.
Bye.
Tune in next time on the Valley Current.